So hello and welcome everybody to the next in your new series of CPD webinars from the Recover Compensate Network. I'm Rosie Brown and I am the network's membership manager, and today I am joined by April Bingham from Bellwether Green as we have a discussion on future-proofing for succession. The webinar will last approximately an hour and we will end with a short Q&A session. So if you do have any questions throughout, you can add these to the Q&A box at the bottom of your screen right now. There should already be a little message in there which you should see. At the end, we'll collate these and go through them all. So I will pass you now across to April to get started on today. And yes, thank you everybody for joining.
Thank you. Thanks, Rosie. And thank you to Digby Brown's Recover Compensate Network for having me along this lunchtime to chat to everyone. And I say chat because I do hope to make this a really palatable chat through, I suppose, some observations that I've picked up along the way. Thankfully, I think this still qualifies for CPD, even though it's not the sort of black letter law that we all sometimes tread on webinars. So hopefully it's some light listening for you, some food for thought. And as Rosie said, there'll be question and answers at the end. Of course, do send your questions into the chat box or save them for the end. But if you're thinking of something on the way through, do post a question. If it doesn't get answered, then by all means drop me a line at a future date. I'm happy to chat about this sort of stuff till the cows come home. It's a bit of a pet topic for me. So I will try and work the slideshow if I can. There we go. I thought I should just probably introduce myself a little. I had a quick look at the delegate list before we got started today, and I do recognise some well-kent faces, but some of you, I'm aware, will have no idea who I am or why I think I should be talking about law firm mergers or succession. My background is entirely in corporate law. I know what you're thinking. It says there 20 years of M&A experience. Obviously, I was a toddler when I graduated university, but for my sins, I did actually do a specialised traineeship and have been exclusively practising in this sort of space: the merger, acquisition, private equity, corporate restructuring, reorganisations, partnership, LLP structures. I've been sort of working on that on the daily for the last 20 years plus. So I understand a lot about the mechanics of deals, but also have seen a lot of the emotional side of deals. I've seen owner managers worry, fret, feel exhilarated about the prospect of selling or passing on the baton in their business. And then I've seen the anxiety of people taking over businesses and all the sorts of things that go through their minds on the approach to completion of a deal. I co-founded Bellwether Green in 2008. So unbelievably the fastest 15 years ever. Prior to that, I'd actually experienced a legal merge from the inside. So I trained at a firm which is no longer around, a firm called Boyd's. It was based in Glasgow, had a small Edinburgh office, and they were I think it was about a 7-partner firm at the time that it was taken over by HBJ Gately Waring. And so I was at the time an associate on staff, and probably found it quite interesting, actually, having already started my career off working on deals, to actually find myself on the inside of one and be an employee who's told one day, we're now under a new regime, so to speak. And that has definitely been insightful as well from the point of view of advising others on their deals and how to deal with integration post-merger. HBJ, of course, itself went on to merge with Adelshaw Goddard, which might be the name that some of you will recognise most, depending on your vintage. But that kind of experience of seeing things from the inside has definitely been informative. And having run a business now for 15 years, just over 15 years, of course, we've seen some of the things, both in practical terms, as I'll come on to. We've acquired a couple of small practices ourselves, but we've also considered many other opportunities. And it's really interesting what you think you know about yourself and your business, and of course, you know, the other questions that come to mind when you're really put under the spotlight to make a decision on something. One thing we did decide to do very positively, maybe about 10 years ago now, is start Commercial Law Network. And this is really the link here between, I suppose, Bellwether Green and Digby Brown, in that we both run networks and have been very lucky to, you know, the two networks are very complementary, and we've worked together on a number of occasions in presenting either informative webinars or CPD events and things like that. But Commercial Law Network has additionally given me a lot more insight into the profession and the different types of practice that's out there. Our network is essentially offering high street and niche practices an outlet for any corporate work or high value real estate work or commercial litigation work that they wouldn't want to dabble in. We can offer that kind of non-compete home for that kind of work. And we also have ended up, I suppose, coincidentally advising quite a number of our network member firms on various events, whether that's assuming a new partner or incorporating or indeed a merge or a sale or an acquisition. So I feel like the combined experience of being a corporate lawyer and knowing a lot of firms through our network has probably given me this unique position in being able to comment on the subject matter today. I mentioned that we'd acquired a couple of firms. They were small, tiny businesses, both sort of sole trader style businesses. Alistair Gordon was retiring, a former Burness partner. He'd had his own corporate practice for a number of years, and he'd reached his late 70s at the point where he thought it was finally time to hand over the baton. And so we were very privileged that they did that with Bellwether Green a number of years ago. And McFarlane Webster, again, was a sole practitioner, Stephen Webster, who had been a former colleague, actually, and for a time joined Bellwether Green, and we acquired the business that he'd been running for a couple of years. So we have done a couple of small, but I would say very conservative acquisitions over the years, and they're insightful and informative, but probably on the simpler end of the scale. That probably sums us up. You know, we want a kind of straightforward, simple life at Bellwether Green, and so we've not, you know, struck out trying to able on lots of different practices. It's just been opportunistic when things have kind of floated onto our radar. I mentioned that I've been advising firms on their own practices, and that advice has really been quite wide-ranging, to the point last year one of the biggest exercises that we'd done actually for another legal firm was a large corporate demerger of some significant value. So that was really interesting to see, I suppose, more of a corporate approach to dealing with a legal firm, because so many firms are in partnership or LLP models. This one was already a limited company, so it was nice to be able to apply the general company law knowledge that we have, and it so happened it was a legal firm that was going through the demerger, but of course there were all the law society bells and whistles that we had to take into account. We had to get special dispensations from committees. All of these bits and pieces were really helpful to, I suppose, add to the patchwork of knowledge that you probably need to be considering when you're looking at law firm, either mergers, acquisitions, or general structural maneuvers. So why is law firm succession so different? And when I say different, I mean, from my perspective, it's very different to the types of deals that I would generally do day to day. I'm usually dealing with the sale or investment or finance or restructuring of companies and groups of companies. And of course, as I'm sure we'll all be aware, the limited company model is a very recent uptake for law firms. There's still so many traditional style partnerships trading. So many people have chosen to go from traditional partnership model into LLP. That's not surprising because it's an easier rollover from a tax point of view. But the considerations around partnership, which I'll come on to, are very different to companies and corporate law. And so the deals that you tend to see struck between law firms look very different to what I would consider a regular M&A deal, where you've got a group of shareholders selling to a third party, or indeed if it's a succession within the business, a management buyout. You know, you've really still got one entity, and the ownership of that entity is changing in one fell swoop. With law firm succession, as we'll all probably be aware, it can be a continual process of adding and removing or saying goodbye to partners. And there can be much more gradual steps in the progression and I suppose the general evolution of legal firms. And that's an interesting difference. The other major difference I've got to say is the value. And might as well probably say this early on, and I hope not to dash any kind of hopes or dreams, but this slightly sad reality is that the prices involved, if price at all is involved in law firm succession, are so different to corporate M&A market. We're not seeing legal firms, being bought for any significant sums of money. And it's all relative. I mean, hundreds of thousands of pounds, maybe, not into the millions. Not, my regular clients, I suppose, are maybe selling their companies for millions. And unfortunately, in the legal market, those sorts of prices are not really likely to be achieved, certainly not in the Scottish SME size legal market. And why is that? That's in part obviously because there's a closed market. So there's a very limited pool of people who are entitled to own law firms, or there at least have been to date, and we'll come on to that. So we've got a limited pool of buyers, and then within that limited pool of buyers who qualify to take ownership of law firms, we've also got limited appetite. I don't know how the rest of you feel about this, but it certainly struck me and a number of other clients and firms who are friends that I've spoken to. There is not seemingly the same appetite among, say, maybe millennials are okay, but sort of Gen Z generation, born in the 90s, not the appetite to ascend to partnership or law firm owner that there was. But, in my day, Gen X day, for me, when I was beginning my career, it was the absolute epitome of success to reach partnership. Now, that's something that some people, quite a large number of young people, wouldn't thank you for. So we have a small set of possibilities in terms of new people coming into the market to buy, which points us toward people who are looking for an exit or to pass their firm on, perhaps not toward younger professionals coming up. It may actually be larger firms who are consuming SME size legal firms. That's one factor. The partnership model itself doesn't really lend itself very well to deals being done. So if you own a limited company, then you have some tax relief available to you if you've held your shares for a long enough time and you qualify for business and asset disposal relief. There are other quirks to deals with companies which allow excess cash that might have been saved up efficiently within the company to be bought as part of the asset valuation on the price. Whereas with the traditional partnership model, you're either assuming partners or and some sailing off with a payout from their capital account, or you're having to do a business and assets sale, which is really just, it's attractive for buyers, but not a great prospect for sellers because it's not particularly tax efficient. Why are deals not done? Another reason is it's quite high risk. Nobody likes the idea of inheriting problems. And of course, particularly in certain practice areas such as conveyancing, these practice areas are fraught with risk. We see that loading in the personal indemnity insurance. The thought of taking on a book of business that may have those risks can be quite daunting for certain types of potential acquirer or merger partners. And yes, that can be mitigated with insurance and runoff cover. But the extent to which that can be mitigated often depends on the structure of the two firms that might be thinking about joining forces, or indeed one being bought by the other. High base costs, by that I really mean the cost of staff, and I'm sure everybody on the call who is employing solicitors will appreciate the expense of doing that. And it's not uncommon for firms to be experiencing higher base costs than is necessarily efficient for the output of their firm. But the market is such at the moment that if you want staff at all, you really are probably paying more than ever before in terms of salary to fee income multiple ratios that we might have seen in the past. Relationships are also such a key thing for so many legal firm businesses. So, a firm like Digby Brown might be differentiated because they have built such a brand and they're selling to consumers the legal services that they might need if they've been unfortunate enough to suffer a personal injury. So a firm like that maybe can say that it has business which is won without any single partner relationship being in play. Whereas a firm like mine, very much the work that comes into my firm is one on the basis of relationships and referral relationships with, in my case, corporate finance accountants, or in real estate's case, either surveyors or other English legal firms, people that will perpetually refer business to us. But those relationships are very personal, and it's often perceived that those relationships can't be passed on very easily, and therefore there's little value in legal firms unless the lawyer who has the relationship is locked in for a period of time in the future. And then probably the last bullet point there, reason why any kind of transaction happening between law firms is slow is I think we're very guilty as a band of professionals of thinking of ourselves as sort of dynamic, strategic go-getters when actually we're probably quite indecisive procrastinators. And I'm willing to sort of accept that's probably me in part as well when it comes to my own business. We do like to think on things for a very long time to the point where things happen at a glacial pace when it comes to our own businesses. We're all very busy and effective when servicing our clients and making sure we're giving them the absolute best service, but it's often like the cobbler's children when we're thinking about things for our own business. And I think that has an impact when you're trying to agree or discuss any kind of transaction with a counterparty on a potential merge. So in putting these slides together, I was thinking about that's pretty much the positions I see it just now. There are difficulties in anything happening from the get-go, sort of almost built into the system for our sector. How might that change? Well, of course, the ABS rules, the long-awaited ABS rules have arrived. And I've got to say, I think us turkeys have voted for Christmas with those ABS rules. It's now going to be possible, it now is possible to establish a legal service provider. It's anticipated that most of those will be established with at least a 51% holding owned by solicitors. That's not necessarily the case. There are other regulated professions who can establish legal service provider firms without holding the 51% majority, and third parties are now able to invest. So we could see private equity, so long as they pass the fit and proper test, we could see private equity coming into the market, which is great for maybe a generation of partners who are looking for an exit in the next 5 to 10 years. But I think what we're going to see is a loss of monopoly and therefore extremely competitive situations arising, particularly in certain sectors within the legal sector, where there's maybe the potential for types of service to be commoditised. So the ABS rules are certainly going to change things. We may find that the number of people interested in acquiring legal firms increases as a result of this flexibility, or acquiring either legal firms or their businesses. I did anecdotally hear that one of the consolidators who's currently operating in the accountancy sector, and it's quite interesting to see that the accountants are just a bit ahead of us at the moment in terms of private equity creeping into ownership. There's now a number of sort of mid-sized accountancy firms with private equity investment bought in, which created exits for a tier of partners, but has now changed the shape of those businesses forevermore. The partnerships will no longer be available to up and coming staff. But sorry, anecdotally, I had heard that one of the accountancy consolidators was in fact in talks around taking over a legal firm. And I can only imagine that they'd be looking to do that using one of the new legal service provider structures. So it's definitely a space that we're going to see a lot of change in over the next 5 years. As I understand it, that deal might have fallen over now, but it's interesting that the opportunity to set up a legal service provider really kicked off around February time this year, when the Law Society had all their ducks in a row to allow it to happen. Almost straight away, there was someone tapping at the door to look at, buying into the sector in a way that would never have been able to happen before. So we're definitely going to see a lot of change on that front. And that, for some of you, that will be good news, because it may be an exit that you're looking for. AI, I feel like you can't have a webinar at the moment without mentioning AI, so I've just bunged that in there. But I'm joking, but of course the AI could change things quite substantially for all of us in the way that we do our day-to-day work. It might allow us to become more cost efficient. It may mean that administrative tasks are dealt with by software in a way that we might have had a person to do a certain role. That's going to be an interesting one to watch. We probably, if we are as firms looking at acquiring or looking at being acquired or looking for a merge, we're always going to have an eye on efficiency, because costs are always going to be a headline point of discussion in any of these kind of moves. And AI can be used in a way, we need to make sure that it's being used and we're not also still paying for the same number of bodies. Or it might be that AI is something that you're absolutely completely turned off by the idea of involving that in your business, and you want to keep a people-based, service-based approach. And that might well be right for the type of practice area you have, family law, for instance. Imagine anyone leaving anything to a computer there. So it's going to be very different for different types of firms, but I can see that in process-driven firms where there's maybe a lot of conveyancing or will writing, there may be a creep towards software solutions that's going to change. I suppose it's going to solve some problems. It might also change the value or potential value of some legal businesses. Insurance trends I've just mentioned because we've noticed in certainly our sphere, the commercial sphere, that there has for a long time been a requirement to ensure carry PI insurance that matches the kind of deal size you're regularly doing. And so, of course, the higher value work you're doing, the more expensive your PI cover is, which is a bit of a pain. But just recently, and as you'll all be familiar, PI costs go up and up and up, whether you've got, even if, like us, touch wood, you've no claims, your costs, your premium's still going up on a yearly basis, and sometimes by quite a significant degree. And when you start to add slabs of the additional PI beyond the base 2 million, that gets very expensive per million. And what we've seen, certainly in some London firms, is rather than trying to keep up with this ever increasing cost and trend, we've seen some London firms say to their clients, you know what, we don't anticipate you'll ever have total loss on this deal, so we're going to insure to a reasonably affordable limit, and you can take it or leave it. And so that's interesting because it brings the cost of insurance down. And I mentioned in the previous slide that the base costs of running a legal firm are quite prohibitive sometimes and mismatched depending on practice areas. So it's just interesting to watch what might happen in insurance trends. There might be a kind of pushback profession as a whole about this ever-increasing level of cover. There may be a tidal shift towards we'll carry the sort of basic insurance and everything else, any other liability is limited contractually. Competing consolidators, I don't think it's any secret that out there in the legal market, there are firms who are very interested to speak to others about sort of joining them. Aberdeen Constein have really run that model. They've grown that way. Anderson Strathern, Gilson Gray, to name a few. There are what I would loosely call consolidators. They're interested in buying up practices. But the more firms that turn their attention to that prospect, then of course we build a bit of competition. So you might have one firm who's of interest to 3 or 4 firms, and that can be really advantageous, obviously, for the firm where the partners are looking for an exit, looking for someone to come and take over their business. So future-proofing, I'm very conscious that that's been the billing for today, and I don't have all the answers. I do have some suggestions that might be helpful and worth thinking about. And to be honest, worth thinking about anyway, whether you've got a deal in mind, an exit in mind for the next 5 to 7 years, or whether you just want to improve your business, or you maybe have an eye on other businesses. And this will give you a framework, I suppose, to gauge how they seem to be doing, or a way of thinking about how they're doing. And number one point, I think, is structure. So I've already touched on the traditional partnership LLP model that most legal firms are running under. I would encourage anybody who is running under that kind of model, whether it's for the purposes of succession or not, to consider incorporating as a limited company. We're structured as a limited company and have the benefit of, we set up as a limited company 15 years ago. And so it was easy for us to conceptualize that. It's a bit difficult when you've been running for a very long time as a partnership or an LLP to think about what the switch over to running as a limited company will look like, and what have been agreements around drawings and profit shares, how that will translate to shareholdings and dividends, etc. But the benefits of running as a limited company go beyond succession. There are just the ability to retain earnings within the company, which you may want to save up and build as a war chest to go and acquire other legal businesses, or to make key hires or lateral hires when the opportunity comes. You can save that money in the company without, the kind of income tax cost that unfortunately partners in traditional partnerships and LLPs suffer every year based on profits for that year. But certainly when it comes to either acquisition, sale, or a senior colleague becoming an owner in the business, actually having a company structure is, in my view, cleaner, better framework. We have the Companies Act supporting the structure. You'll all be aware from basic, earliest of law school days, the Partnership Act is so antiquated and sparse, and the LLP regulations are not much better. So often it's just your luck how good your partnership agreement or your LLP agreement is. which leads me on to the second bullet point, which is making sure no matter which structure you're trading under, you do have good governance and it's repeatedly revisited to make sure it's fit for purpose. Just recently helped with an accession to partnership. The partnership agreement wasn't that old, but it was totally unfit for purpose. It didn't cover what should happen for new members joining, or particularly what should happen if someone leaves. It said that they'd covered the basic that the partnership should continue, but hadn't talked about how a person should be paid out their capital account, how a new joiner should be sharing profits. It had been too tightly tailored for a small set of partners and didn't really envisage any future change. So I would encourage everyone to think about what's in their partnership agreement or their shareholders agreement if they are in a limited company, and make sure that's revisited ideally every 3 years, because things change quicker than you imagine, but at least every 5 years. Know your numbers is quite a generic line there, but it's probably a seminar or a webinar of its own. But I think we lawyers as business people are often on the lax side when it comes to knowing our bottom line, top line, profit margin on every service line. Certainly I know my non-legal clients, who are by far the majority of my clients, certainly put me to shame in terms of how well they know their business right down to the penny in terms of profit margin on certain products or service lines that they're offering on each employee they're employing. What is the output of that employee? What is the cost of that employee? What are the hidden costs of that employee? I think we're, as a profession, and sorry for all these generalizations, but it's quite a general audience, I think as a profession, we're quite poor at actually knowing the very finely tuned details of our businesses. We broadly know we're doing okay or we're not doing so well, and we need to either up the ante or we're quite comfortable. But I don't think we really nail it when it comes to knowing our numbers. And of course, if you're trying to argue for some value for your company, if someone's perhaps looking speculatively at making an offer for your business, whether that's a business and asset purchase, or if you are a company acquiring shares in your company, you need to know what looks like the right price and what's a price that you can live with. I mentioned at the beginning that we haven't seen prices being particularly high. There's certainly some things that I'll come on to that you can do to perhaps achieve a maximum, and knowing your numbers is absolutely the starting place, because if you know where the weaknesses are, if you know where there is too much cost, or you're not squeezing enough out of your existing team or what have you, then you can start to make improvements and argue for a better price for your business. If you're not looking at a sale or an actual transaction, then the other obvious and more traditional route for succession in your firm is for senior employees to ascend up the ranks and take over the mantle as maybe partners wind down, become part-time or become consultants. And I think it's really important to, and I'm continually thinking, we need to improve this as well. But I think it is really important to have a route mapped out for senior employees so that they can see, if that is your planned succession structure, how they fit into it and what they need to achieve to ascend. And that can be very difficult because it feels quite subjective often. And certainly the much larger firms, larger corporate law firms have had to, because they have so many people, expectations to manage, they've had to build with some rigor. And some of you, I'm sure, will have experienced working within these frameworks. If you've worked at larger firms, they've had to build very tiered systems where it's all set out in writing what you must achieve to get X, Y, and Z in terms of promotion. I think for smaller and medium-sized firms, it's so much more subjective and so much harder to really pin down, but it's worth certainly giving some time and thought to mapping out a route for staff and making sure you're talking to them about it and sticking to it and holding them accountable to it. I've noted relationships in terms of future proofing. There's probably two aspects in relationships. On the one hand, if you're trying to exit your business and you want to hand the baton over to someone else, you need to make yourself dispensable. So you need to rein back, I guess, from some of those client relationships that you have probably worked so many years to build. And it feels counterintuitive, but the trouble is, if you're the only person that the client is sticking to, then it's very difficult for anyone, whether that's a senior employee coming up the ranks or a potential buyer of your business, to envisage the client staying with them if they, either buy in, if they're an employee who's being asked to make a professional partnership contribution, or a buyer paying you a price. It's difficult for them to think, will those clients stick around if so-and-so's not here anymore? I don't know if they've got relationships really with anyone else. So you've got to really think about how to circumvent that. And one way is to build your brand. And, hats off to Digby Brown, who built a tremendous brand, which is bigger than any one partner in that firm or any number of partners in that firm. It's the brand that the clients are going to. And that is certainly one approach. The other approach is to make sure that other team members are close to clients, not just you. And that can be a bit of a daunting prospect because, sometimes we can feel quite protective about our client relationships because perhaps our profit share is tied to income from those clients. Perhaps we're worried about other people stealing those clients internally. And that is a tough nut to crack, what you do about that. But it's going to differ probably for every firm and every practice area and every lawyer, really, depending on their personality. But it does lead me into the next line, protections, which is, of course, if you are going to entrust other staff members with close client relationships, then it's really key that you do, of course, put in place appropriate protections in the form of restrictive covenants in employment agreements or service agreements or partnership agreements, or, again, depends on your structure, but making sure that the clients belong to the business or the entity running the business and are not going to be easily lifted or pushed or solicited by an employee who moves on. That's really one of the hardest things to get right. We all know the issues with enforceability of employment-based restrictive covenants, but they drafted properly, they can be enforced. We've just recently interdicted some employees who tried to take a number of clients from a professional services business, not legal, but the protections can be utilised. They just need to be well thought out, well drafted and proportionate. And this comes up in mergers too, because sometimes, looking back to, I don't think it would be a million miles from obvious to say that when the merge that I observed when HBJ took over Boyd's, there was a period of earn out for the former partners, so they were paid over a period of time. But there was risk for them in that, because if staff members left or were made redundant, as happened to some of my colleagues in that process, that meant client relationships were getting chipped at. It meant that if those protections weren't in place properly, they were under threat, which meant the income generated from those clients, and therefore the earn-out payable on them, was under threat and being ebbed away. So it's a real concern in general, making sure that clients are as sticky as possible to your brand, your firm, not necessarily one person. Not just for succession and as people move up the ranks, but certainly for any kind of sale or merger. Positioning, I've just mentioned, because some of you might be familiar with a slightly unusual transaction that happened with a firm called Paciti Jones. And that was an interesting one, because as I understand it, and this is anecdotal, I wasn't involved in the transaction, but as I understand it, they ran a deal which was more akin to a sort of corporate transaction. They got quite a significant price for their business, I understand, but that was because they had positioned themselves very much as a key estate agency in the West End of Glasgow, in a prime area. And so it's interesting just that positioning yourself in a certain way might help you to distinguish your business and achieve a bit more kind of traction if you go to a market to try and sell your business beyond the norms of just a regular legal firm. And it related to that is USPs. Some legal firms will have a very specialist knowledge. Shipping, for instance, might be one. Tax, and they might be very attractive bolt-ons to other larger firms. If you've got a USP like that, then it can certainly work to your advantage in terms of being in demand. So it's worth thinking, is there anything about our practice that's a bit different, that can be built on, shored up, that we can make more of a thing of? That one may be a bit more obvious, but it's certainly worth mentioning in terms of future proofing. Conscious I'm running out of time here. Who'd have thought I'd have so much to say? Building a deal, I've just put a few bullet points here for those of you who are thinking about some kind of transaction, whether you're buyer or seller, or we call them mergers all the time in the legal sector, but let's face it, there's usually someone who's bigger or with deeper pockets acquiring the other, and it might be presented to the outside world as a merger, but really you've got a bigger firm or a smaller firm, being taken over. That's more likely the reality. But what I see happen now and again, and this happens in non-legal deals as well, is people faced with limited options in terms of an exit, will quite often project onto a potential merge partner or buyer or acquirer, or indeed target, if they're thinking about buying. They'll quite often project that it's a good fit. And I've just said really, because sometimes, you're a bit overly optimistic. It's a bit like dating. You might think, yeah, that seems like, that's a good fit for me. And actually, when you really dig down, and I would encourage anybody looking at these kinds of transactions to really dig in and do diligence both ways. You've got to be as sure as you can be that it's a good fit, because that's going to make or break the success of the enlarged entity after any kind of completion. Buyer and seller structures, I just mentioned here, you've got to bear in mind that there are so many different types of business structures within the legal sector that deals can look quite odd, quite different. Everyone is. I think every single one I've seen has been different. You've maybe got a limited company buying the business and assets of a sole trader, or you've got a LLP who wants to merge with a limited company, and it's how is that going to best work? So these things can add complication, and it's worth, if you have the time, to do your homework and understand what are the likely implications of trading as a legal firm, as a limited company, trading as an LLP, trading as a partnership, and how will those different types of trading structures plug easily or not plug into mine or any kind of plans I have for the future. If you're getting a price for your business, be prepared that it's likely to be paid over a period of time, and maybe relative to fees and clients sticking around, as I mentioned in the example I gave just a minute ago. Do think about security for that. Sadly, we're in times now where law firms, and have been since 2008, law firms have been going bust. Very sadly, it was not really a problem we had to worry about in the past, but it's still, even the last couple of years, a couple of firms have disintegrated. So, if there is deferred consideration or earn-out payable, please don't just trust that we're all professionals and of course we'll all have to pay our debts. With the best will in the world, perfectly credible and nice people at law firms have suffered insolvencies, and so we have to be careful about making sure we've got security. Announcements. So I'm sure it will not have missed any of your screens that McRoberts and Morton Fraser have announced that they're going to merge, which is really interesting because I think I first heard about that possible merger about 10 years ago. There's been gossip about that for a very long time. Obviously, whenever that gossip started, it went off and has now come back round again, but they've made a really interesting decision to announce this before the deal is done. And that, of course, carries some risk that it doesn't happen, some risk that you lose staff, or that, staff think, well, I don't actually want to be part of a bigger, an even bigger still firm. So it's an interesting approach to take. I understand why they maybe thought it was worth doing, to stop the rumour mill and to allow a kind of very clear and transparent process. But it'll be really interesting to see how long it takes to get from this point to completion of the. But obviously, wish them all the best with it, and it's definitely been an interesting move, and it just, I think, goes to show what's probably in the post for a lot more firms, a lot more consolidation in the marketplace. Don't underestimate the process. I've spent a bit of time with a few firms trying to get some sort of transaction done, and I can honestly say probably in every case they've underestimated how long things take, how long the Law Society takes. And that's not a criticism of the Law Society, but they just have processes and they're busy and they have limited numbers of hands to deal with things. We underestimate how slow moving we as lawyers are, as I touched on at the very beginning. So I think allowing plenty of time to get a deal or a transaction structured or done, or if it's just an assent to partnership or an accession to partnership, making sure there's plenty of time to get the partnership agreement sorted while maybe someone's serving their notice elsewhere. Definitely think there's a propensity to underestimate what's involved. And I've said take advice from deal doers just because I think there's a danger, there's that old chestnut about a lawyer has a fool for a lawyer who represents themselves as a fool for a client. And I wouldn't go so far as to say that when it comes to doing mergers and transactions. I'm sure there's any number of lawyers who are perfectly capable of striking a deal and writing a contract for that themselves. But I think where they maybe miss out if they don't take advice is actually probably on the financial side. So when I say take advice from deal doers, yes, by all means, consult someone who's a corporate lawyer. That will undoubtedly help in terms of structure and what's normal and conventional in a deal. But actually speak to a corporate finance accountant as well, not just your regular accountant necessarily. If your regular accountant has someone at their firm that has experience in transactions and deals, then great. But if they don't be afraid to go and just for this one-off piece, speak to another type of accountant who's used to doing deals, because the danger of not doing that is missing out on things like recovering excess cash in a tax efficient way, or just making the most of this one pinnacle transaction that might be the beginning of your retirement. So just a couple of quick case studies, and then I'm conscious we've got need a little bit of time for questions. But very quickly, I had one deal so neither of these transactions went ahead, which is why I've picked them. They ended up with problems. One was a company, so a legal firm trading as a company, were in talks with a partnership. They were competitors trading in the same kind of geographical area. They had different drivers for I suppose what was potentially going to be an acquisition. The company was looking at acquiring the business of the partnership. The partnership partners had just reached a certain age where they were ready to wind down, wanted a home with less stress to work for a short period, and then intended to retire. The company they weren't my clients, but they're probably thinking, well, that's eliminating a competitor in the area, maybe a bit more kind of hands-on help for the next couple of years. But the parties did a set of heads of terms, which were done by the time it arrived on my desk. But But I think my clients hadn't really, as a partnership, hadn't really thought about the risks that were inherent in the heads of terms they'd agreed. So, for instance, they weren't receiving very much money up front. There was a price agreed. It was payable over a long period of time, payable by a company. There was no security. And, you know, when I pointed this out to them, it was, you could see the light bulb going on, like, oh yeah, if we were advising our clients, we would tell them, if you're owed money and you're owed money by a company, get a personal guarantee, get some kind of security. And they just, it's funny how when they've been setting out these heads of terms for themselves, they hadn't really thought, they hadn't done that risk analysis for themselves in the way that they might have done it for a client. So worth just making sure that you're keeping track of, I suppose, the types of advice you might give your client, taking a step back from a deal. In the end, I think there were some mismatched expectations in terms of, and this probably related to the differing drivers for the deal. But importantly, and so the deal didn't go ahead. But what was really nice to see about it was the parties spoke, had heads of terms. There was some difference of opinion and a bit of disappointment on both sides about this difference of opinion, but ultimately they parted in good terms. And I think that's really important because it's a small place, a small sector. And if things are discussed and don't go ahead, then I think it is really important to be able to sort of potentially revisit it again in the future. Maybe that's what happened with McRoberts and Morton Fraser. But leaving the door ajar is always helpful. And you're going to have to deal with people, of course, in your day-to-day. So it's useful to part in good terms. But again, I would say on this one, the timing was underestimated. And, you know, our clients found themselves a bit up against it, in that they'd mapped out a timeline for themselves and their, you know, retirement, which had to be pushed back when they realised actually this deal's not happening. So they'd maybe not given themselves enough time to hammer out the detail of the deal, but had jumped into the future with their sort of timeline. And so just being realistic is probably helpful from the get-go. The next one should have been the simplest thing ever, but it ended up being so complicated because we had a sole trader who was going to be passing the business name to their only employee. And the Law Society were struggling a wee bit with that one, just because it meant we had to do a cessation of practice of the sole trader. And that the Law Society were very concerned about, if a member of the public was to log on and find the name of that legal business, they should be able to see who owns it. And of course, that had to change overnight. So that was taxing the Law Society a bit. But in the end, actually, I don't think that deal, it hasn't gone ahead yet, and I actually don't think it's going to go ahead, because I think the employee in this case is just finding it all too much and has in fact been not ready and is too busy with work, notwithstanding the employer who's trying to pass over the business is saying, look, put client work to one side, I'll help you with that, and just concentrate on doing all the regulatory things you need to do to get up and running. And it's just not happening. And the timing bit comes into play there, because we're approaching a practice year end, and it's looking like the employer here is going to have to renew PI for another year, whereas they'd been hoping that this would be the last year of PI and they'd be getting runoff cover in place and the employee would be taking over at the end of October this year. But they've not left themselves enough time and they're too busy. So it's going to run on probably into the next year. I'm super conscious I have rambled on and I must leave at least 5 minutes for questions. So Rosie, I'll pass to you.
Thank you very much, April. And that was all really informative. We have a few minutes for questions, as we've said, but I'll just do a little bit of housekeeping on my end. If you do have any questions that you think of after the webinar, you can send them across to recover@digwybrown.co.uk, and we can get you in touch with April so that we can get those questions answered. Niamh has been watching the chat box for us, and I think we have a couple in. So Niamh, I will pass across to you.
Absolutely, thank you, Rosie. So, yep, I think we've got time for one of the questions that came in through the chat. April, someone has asked, how can you get security in a deferred consideration situation or payment over a period of time?
Well, again, it depends on structure. If you're being paid by a limited company, I think the simplest in a legal business is to ask for a personal guarantee from the directors or shareholders of a limited company. If you're being paid by a partnership, a traditional partnership, then you would need to look at some kind of, at least a registrable instrument that allows you to enforce the debt without judgment. So something that allows you to register the debt in the books of council and session. And you might go, depending on the amount of money, you might go so far as to look at security over a trading premises or some kind of standard security. So it really depends on the type of entity or party that's owing you the money, what kind of security options are available.
That's great, April. Thank you so much. I think that is all we have time for question-wise just now, but I'll pass back to Rosie now just to close off our session.
Thank you very much, Niamh. Yeah, as I said there, if you do think of any questions, please let us know, recover@digbybrown.co.uk, and we will get those answered for you. This session has also been recorded and will be available for downloads next week, so look out for that as well if you do want to go over any of the good stuff that April was just talking about there. We have our October webinar, which is upcoming, and you will get an email for that in the next couple of weeks as well for registration. But just to finish this from me, thank you very much for attending today. Look out for more to come and enjoy the weekend when it comes. I will pass over to April for her final words.
Yeah, thank you very much for having me and for your attention for the hour. That's probably the worst Friday lunchtime you've ever had, but have a great weekend when it comes, and look forward to hearing from anyone with any questions.
That's brilliant. Thank you very much, everyone. Thanks. Bye-bye.
Bye.